My writing process is when I get a case for an appeal, the first thing I do is review the trial court record very thoroughly. I always prepare a detailed written timeline of the case very early in my review process. I go through just step by step and document every stage in the case, and I put citations in the timeline to the relevant documents in the trial court record. I have like an index already prepared at the beginning, and it gets me very conversant with the facts and issues in the case right from the start. Then after I've completed that, legal research, that just depends on the nature and complexity of the issues. If it's an issue that's especially complicated or one where the law is uncertain, I tend to be kind of a heavy user of treatises and law reviews. So I'll go and I'll try to find a treatise or a good law review article that summarizes the background in an uncertain area of the law, and then use that as a guide to get me going in the leading cases that I need to familiarize myself with. When it comes to actual drafting, I usually start with what are for me the easier or more straightforward parts of the brief, that is the background, the factual and legal background sections. Then I write then I'll write the advocacy argument sections of the brief, applying the law to the particular facts in the case. And then at the end, then I go back and rewrite the stuff that I wrote at the beginning, the introductory and background things, because they're always too abstract when you write them the first time. And after you've actually written the argument, then you go back and hone them down and work more advocacy into those sections. It's difficult. I think we get tunnel vision sometimes in working on a case, and your brain becomes accustomed to thinking along a certain line, and if you hit an obstacle, you can really get stuck. So I like to try to get a fresh perspective when that happens for me, which I do in a couple ways. One is, time permitting, I'll put the case away for a few days and not think about it, and then return to it hopefully with a fresher perspective. I sometimes do my most creative thinking. I always do my most creative thinking early in the morning after that first cup of coffee, often before I've actually gone into the office or formally started work. So if I'm having trouble with a project, I'll try to think about it when I'm getting ready for work in the morning, and I'll often have some good ideas and end up having to run down to my office and quickly type in some things before I forget them. But maybe the most important thing, though, is to use your colleagues. And to, if I'm stuck, I can get a fresh mind instantly if I can find a colleague who's willing to talk about the case with me, and often they'll see things that I'm missing, and that will help to get the wheels rolling again. To me, it's striking the right balance between advocacy and legal analysis and exposition. And I see a lot of briefs that I think err in the direction of putting too much emphasis on the advocacy and not enough on the thoroughness and clarity of the legal analysis. So I think that appellate courts are very smart and very well informed, and they are going to give very close and careful attention to the legal reasoning underlying all of the arguments made by all of the parties in the appeal. And so I think it's important both to explain your own position to the court as thoroughly and clearly as possible, try to persuade the court that your position is legally correct, but also not only to direct the court's attention to your view of the case, but also to take on the other side where they're strongest, and to really try to come to terms and persuade the court why, even the best arguments for the other side should not prevail in the case. Sometimes you lose, as I did in the appeal in the context. I think that if you really go through that process very vigorously, then it helps the court to write a decision that will be clearer and will contribute more ultimately to the development of the law, which is, to me, the ultimate public policy value in appellate litigation.